Hello, my name is Megan Raymond. I'm the Manager of Programs and Services here at WCET. Today you are joining us for an exciting webcast. We have a lot of content to get through, so we're going to go ahead and jump right in. Law and Disorder, the revision of laws affected by the Internet. We have two wonderful speakers today, and I'll get to those quickly. But first I want to thank Blackboard Collaborate for making the platform available. If you have any technical issues, you will need to contact Blackboard directly. The speakers are the only ones with mic access today, so please do communicate with us and use the chat box. It's a great place to post your questions as we move along and share resources, share ideas. This is being recorded. We will send out a link to the recording archive, the PowerPoint slides, and any resources that are shared, including follow-up to any questions that we didn't get to answer during the live webcast. We're going to stop periodically for questions after a few of the sections. So Richard Katz, our moderator today, will be pulling those out, and then we'll do a brief Q&A after each section. And then hopefully we have sufficient time toward the end of the webcast to respond to additional questions. But as we go along, do add your questions to the chat box. Our moderator today is Richard Katz. He's a longtime friend of WCET and formerly a member of our Executive Council. He was previously the Vice President of EDUCAUSE and has launched his own consulting firm based here in Colorado. Richard, take it away.
Thanks a million. Well, good morning, good evening, good afternoon, or good night, everybody, depending on your current time zone, and welcome to this session. I assume that you'll agree with me that it's an interesting time. Experts are coming under pressure from new voices who are early adopters of new technology. We're seeing new organizations emerging to deal with the social, cultural, and political changes. There's a struggle to revise the social and legal norms, especially in relation to intellectual property. The concepts of identity and community are being transformed, and new forms of language are coming into being. And of course, educators are being pressured to prepare their students for this newly emerging world. I would love to take credit for what I just said to you, but in fact, that was written in the late 1960s by University of Michigan historian Elizabeth Eisenstein, as she was describing the wake created by Gutenberg's press. So it's good for us to keep in perspective that this is a disruption on the order of magnitude that we've seen before. So today we face another period of disruptive change, and we once again, I think, need sharp legal thinking and an historical perspective to help us find our bearings. And we're lucky to have Tracy Mitrano to help us with that. Tracy has both a JD and a PhD in history, so she is well suited, perfectly suited. She's got a long-standing and high-profile affiliation with Cornell University and is the principal as well in Mitrano and Associates, LLC, a consulting firm that focuses on higher ed and nonprofits. She's really, in my experience, been higher education's go-to person on those laws that are being redefined as the torrent we call the Internet carves new channels through all of our social, legal, family, and political structures. She's also the person I go to for advice on how unchanged laws really need to change. Her range of interest is extraordinary, spanning virtual global universities, online education, digital literacy, social networking, electronic surveillance, information management, privacy and security compliance and risk management, and others. She's been on many, many boards. She is the well-known author, as many of you know, of the Inside Higher Education blog on law policy and IT, and she's an absolutely wonderful person. She's not just smart, she is, I like to say, enraged and engaged, passionate and witty. She's a wonderful mom and a wonderful friend, so I'm honored to share her with you today. So I'm sorry I took so much time, but Tracy, you want to get us started?
Wow, Richard, after that, I feel overwhelmed and very grateful, of course, for all the interactions that we've had over the years and the work that we did when you were Vice President of EDUCAUSE, and I'm very grateful for that introduction. I will go ahead and begin the slides here because we do have a tremendous amount of content. And so in my welcome to all of you, I would like to paraphrase the wonderful line in All About Eve, which is, buckle your seatbelts, we're going to be in for a rocky night. I see the internet right at the beginning as not just a technology, but a world historical phenomenon, and it represents the tipping point for so many of these transformations that Richard spoke about. And it is great to have the quote from that book about the printing press and see how much it applies to our current circumstance. The one phrase to sum these large-scale transformations up might be to say that we now assuredly live in a 21st century global information economy. And in my analysis, I borrow from Lawrence Lessig, the internet law scholar guru. His early book, Code, suggested that no analysis of the internet is complete unless you at least think of these four factors: the technology, law, market, and social norms. Of course, we're going to focus on the law today, but never in a vacuum. Law stands both as a shaper and is shaped by these other circumstances. There are 5 areas of law that I've identified for this 1 hour context to discuss, but we could talk about many others. Export control comes quickly to mind, for example. But these areas seem to be the ones that are most touched and have created significant disruption in areas that I hope to explain in more detail as we move along. So copyright being the first, librarians, IT professionals, and certainly the content industry let us know right away that this was going to be a challenge as the internet became public in the early 1990s. Very quickly, the definition about the rights to copy and distribute, display and perform, and the scope being so extraordinary, the original work in a tangible medium, the terms having already been very robust in 1976 when this law was promulgated, and I don't need to explain to you where technology was at that point and where it is today, and this law for the most part has remained intact. The addition of the extension in 1998 was from 50 to 70 years and from 75 years to 95 for a corporation. The damages have also gone up. They have always been $750 to $150,000, but with the No Theft Act of 1997, not only was profitability removed from the intent that had to be proved in order to secure infringement, but the amount was raised by another $100,000. So we're now up to an intentional infringement that really would go with someone who's doing it in order to make a profit to $250,000 per infringement. And I don't need to tell good technologists, and I've run down the list of all the esteemed people and friends, colleagues who are on the line today, that you understand with the internet that infringement can occur multiple times within seconds. So the case and market adjustments that illuminate where we are with copyright infringement, at least on the peer-to-peer sector for the most part. Early on, we had a full-blown arrest of a student at Duke University who set up servers and advertised the services of free content. There is the famous Thomas case. This is the single mother who does not have highly remunerative work, but has faced now a judgment of in excess of $1 million. And it has proved many points of law, but the reason I raise it here is to say that when the RIAA, who represents the various labels, goes to court on these matters, the law is such that they always win. And in fact, they often win with even higher judgments than one might expect. Ms. Thomas could never pay back the amount of money she owes now and is on some type of agreement with them, but she is clearly a poster child for advocates of reform. And she's a poster child for the RIAA in making it clear that if they really want to nail someone to the wall, they can do it. There was a student at Boston University who many years ago had the law professor Charlie Nessens from Harvard Law School represent him in a similar case, this time through the Boston University network and so forth. And he also now still has hundreds of thousands of dollars, not in legal fees. Professor Nessens did it as a grace, but to the damages that he owes, the labels affected by his proven by law infringement. You might all remember the settlement letters that came through many years ago. These were much lower numbers. I mention it here because it was a very interesting period in how the content industry got higher education to do its dirty work, forcing the hand of administrators to forward those letters to the alleged infringers because, well, we knew who those people were. They were on our network. They did not. And it was a very clever ploy. Financially, the RIAA lost significant money. It's part of the reason why they didn't continue the program. But once again, it demonstrated the law would need to be fixed before one could adjust for the new technologies and how they work. That was firmly established then in the Higher Education Opportunity Act with the peer-to-peer provisions that require campus ISPs to do more and above any other ISP, commercial ISP in the country. And as we go for another round of the Higher Education Opportunity Act reauthorization, those provisions remain. If you talk to your government affairs people, you may want to ask them to ask if they are still necessary. The regulations that the Department of Education put in to support that rule are so antiquated that I can give you a very fast example by referring to iTunes and Netflix for market adjustments. So where the law and social norms conflicted, we then eventually had some market adjustments. In the early years of file sharing, there were no market alternatives. If one wanted the content online, they would get it from these sources that so clearly in all these cases above proved infringement. Now we have iTunes as well as many other, and I know there are more than need to be listed. And Netflix is a good example in terms of video content. Back to that HEOA reference. Now our highest bandwidth users on campus tend to be either through FaceTime or through Netflix. And this obviates the regulations in the HEOA, which called upon higher education to identify its high bandwidth users in the assumption that that high bandwidth use was associated with infringement. It is no longer associated with it. Most of those regulations are antiquated by changes in technology and were even when the regulations went into effect in 2010. It would be great if our government officers could spend some time reviewing all of that. The disparity between the law, the technology, the social norms in the market remains the same today, even though there have been these various revisions and adjustments. I have a 10-point, I know I sound like I'm running for office, but I have a 10-point copyright reform schedule here. And because we've got so much content, I'm not going to go through each of them now. I'd be happy to take questions. I do want to say, however, that there's a darker cloud in the background of this entire debate, because the failure of Congress to reform copyright has meant that in the areas of market adjustment, iTunes, ebooks, even Netflix, copyright is almost becoming antiquated as something that only functioned historically for print, because now it is licensing and contract that is overtaking the default copyright. And so I'd like to make a prediction to you. If, and I don't believe we will have it, but if we have Congress do a significant reform of copyright law in order to fit the new context, it will, in a not too far away future, not really even be worth very much because it's already being underwritten by licensing and contract. Okay, let's move on now to the next area with some question and answers. Richard, if you would go ahead and facilitate that.
Well, certainly. Let me first of all thank you for that and encourage everybody to fire in some questions. I have a zillion, but I won't attempt to dominate the conversation. But first of all, you know, do you think that fair use is dead? And before you answer, let me ask the second part of that question is, could you talk about the intersection of fair use and information literacy? Are we wall around our best and most rigorous, if you will, information, leaving some students, if not many students, you know, left to use open resources that may not, frankly, be up to the task?
Those are great questions. I think the most vibrant living aspect of copyright law remains fair use. I say this for a couple of reasons. The development of copyright is almost in a global sense, Richard, like that of Western history since the dawning of movable type in the Western context. Asian countries or areas, cultures had it much earlier than the West. But with the simultaneous developments that were going on economically and politically and so forth, not the least of which was European expansion, we see the development of printing press and all that came after it, setting the tone first in Europe, then in the so-called New World, the United States, and then now in the developing countries, mostly in Asia and Africa. Curiously enough, Europe does not have fair use. There's very little that functions as fair use does under U.S. law. They have something different called moral rights, and that seems to give sufficient authority to owners and or authors, and they have not built up fair use. If you look at the country that was the most violative of fair use or of copyright in general in the 19th century, it was the United States. We had no reciprocal agreements with Britain, and therefore we copied Dickens and Thackeray and Bronte with abandon and passed it out. And we see that with developing countries today, where they don't have the economy to support copyright in the way that it has largely been supported in the West, or at least before the Internet. So I think of fair use as the most important tool in higher education's toolbox. And in addition to that, I want to say that it came first about as through case law, but then was codified in the 1976 Copyright Act. And now there's been an addition to it, very important to the Internet, called transformative works. And that would include, say, a thumbnail sketch that was found to violate a number of the fair use factors, such as amount, but the court overall saw that it was in a transformative context and so allowed it under fair use. And I think this could too be codified if we had the right type of reform. But in the meantime, I'm still a very huge supporter and fan of fair use. In terms of information literacy, you make an excellent connection. We must still be teaching students, faculty, staff about this issue for every possible reason, the most conservative being risk management within the institution, and you don't want to have liability and so on and so forth, right on through the larger political questions of what are we going to do, because I do not think it is propitious for a democracy to be operating under licensing and contract to have the content it needs to function for citizens to be informed about their society and to work as democracy is supposed to be with its core concept of citizenship. And so to nip the problem in the bud, we really must think about a reform of copyright, and information literacy is perhaps our best vehicle to do it.
Well, thank you very much for that. I hope that I'm reading my chat box correctly, and I have not seen any questions. So jump in, folks, when you can. But I'm going to encourage you, Tracy, to move along because you've got a tremendous amount of more ground to cover. And if anyone has a copyright question that I've missed, I apologize and encourage you to repost, and I will try to catch it on the rebound.
Okay, very good. Thank you so much. Let me move now on to the next slide. Under computer fraud and abuse, the definition of it essentially is not breaking electronically into protected computers. In other words, don't hack into a computer connected to a network system. This law, which was first promulgated in 1986, is so old that it does not even have the word Internet in it. The term protected computer is now interpreted to mean on a networked system or on the Internet. And this is how antiquated the law is to begin with. Its main purpose was to provide criminal penalties for breaking into banking and financial transaction systems that were already networked even before the Internet became public. And so it has since then, now that the Internet is open and we have people experimenting on it all the time, used for all forms of security violations on all devices connected to the Internet. In other words, the scope of what it now covers is exponentially different than what it was originally designed to deal with. There are a number of cases that give us some insight into the use of this law. Robert Morris was a graduate student at Cornell in 1987 when he, visiting a friend at MIT, released what was called a computer worm. We would call it malware. And it had the effect, unintended according to his testimony, of shutting down almost a good portion of what then was the Internet. His father worked for the National Security Administration. He was a student otherwise in good standing. He said he didn't intend for it to have this effect. Nonetheless, he was prosecuted under this law and did not serve any time. He went on probation. I do believe there was a fine that had to be paid. Cornell did have him leave the university. But he went on and got a degree from Harvard and has since been an assistant professor. He might be a full professor by now at MIT. And so very interesting that before 9/11 and all of those events that have changed the profile of how we think of computer incidents, we had now Professor Morris with this experience back in the late 1980s. Some of the other examples I have here are much more contemporary. This is the law that Bradley, although now would like to be referred to as Chelsea Manning, was prosecuted under and is now serving a hefty term. That would be through the military courts. This is the law that very sadly was brought against Aaron Swartz, who decided in the wake of the indictment and his decision about whether to accept a deal or not, decided to end his life. And I recommend the movie The Internet's Own Boy if you're more interested in that. It gives you at least a little more history on that case. If Edward Snowden were to come back to the United States, I'm pretty sure that he would be also prosecuted under that law. So you see the original intent for banking and financial institutions has long been stripped by the circumstance and the broad scope of the Internet. What would I do if I could wave a wand and reform this law? I would begin by distinguishing real intentional criminal acts from security incidents of any wide variety of intent or effect. I would, again, identify the type and degree of a security violation to put it in some type of perspective and map the punishment to the nature of the crime, looking at intent, purpose, and effect. I would also be very clear to create explicit exceptions for innovation and research. There is an implicit chilling effect in this law, especially with its extraordinary consequences, that hasn't been talked about as much as some other areas of law, such as the Section 1200 provisions in the Digital Millennium Copyright Act. That we have a challenge to innovation and research. So I'm prepared to take a few questions if people would like to ask about this specific law at this point.
Would it take you too much off the track, Tracy? I've obviously missed Deborah's question about HEOA. Would you be okay with that?
Oh, sure. What is the question, Richard?
Yeah, could you give more detail about the HEOA and what government relations folks in particular could or should be saying about, quote, high bandwidth users and other language in the existing legislation?
Sure. So under the HEOA, when it went into regulations, there were 4 ways in which a campus ISP, and I must emphasize that it's only campus ISPs that are required to do this, in other words, institutions that receive federal funding. And the 4 remedies were to identify high bandwidth users, and I've made the point that if we were to do that now, what we would find is non-infringing legal uses. If there was also a provision that goes all the way to the extreme about using fingerprinting technologies. Audible Magic is one commercial vendor that would then block traffic. It would filter and block traffic, but that does mean then that the traffic is being monitored, and that device and its process really might violate many campus policies about not monitoring the network for content as a practice. There's a DMCA response where there's some type of judicial action that occurs within the university. That is the least intrusive because it's not intruding with the network activity, traffic, or packets, but does then call upon judicial administrators to adjudicate those cases. And that can be very helpful to teach students who don't understand either the law or the technology or both to appreciate the liability that they bring onto themselves. And then there's a 4th one too that's sort of a hybrid of high bandwidth users or big users of the internet, that they also be identified, and that one is antiquated as well. I didn't define it very well. I don't recall the details of it, mostly because it's no longer really applicable, I think, to these cases. But college and university ISPs must take one of the 4 of these approaches. And what I'm trying to suggest is there are a couple of them there that are completely antiquated by virtue of how the market has shifted the notion of infringement.
Thanks. And backcasting one more time, and then I do have a question that's on the point that you're on. And that is, do you know anything about, and if so, what would you say about fair dealing in the UK?
Fair dealing is, as the UK tends to be, a little bit not exactly Europe and not the United States. Fair dealing would be a good example of it, and there are several other examples in many areas of law. Fair dealing is not as broad as fair use, but it is not as restrictive as the absence of fair use and moral rights imposes upon users in Europe. And while I don't know a great deal about fair dealing, it sort of has this precedential notion that originally allowed for fair use to be codified, but a notion that there are sometimes some conditions, and this would go with England, UK's perspective on free speech. Ours, of course, is broader than theirs, but they were a leader in it, in Western civilization, law, and thought. And so there are some exceptions that exist in the UK under copyright law that are a little bit broader and like fair use, a little bit broader than they would be in the civil system in Europe, but they are not as broad as they are in the United States. And I mention that because, you know, we're so desperate to use fair use, but we should really recognize that it does allow for a kind of elasticity that other countries don't have, curiously enough.
Well, thanks. And jumping back into the present tense of your presentation, could you discuss the penalties for violating the Fraud and Abuse Act? And if you could, are there any recent examples that would illustrate it?
Well, I think Aaron Schwartz's case is the most recent of public note. I may not have exact years right, but I think it was upwards of 35 or 36 years that technically, if you took all 13 laws, he was alleged to have violated, and most of those 13 had to deal with the Computer Fraud and Abuse Act, and added up all the potential consequences of it he was facing somewhere in the ballpark of 35 or 36 years of incarceration, and I don't even know what kind of monetary penalties. Now, I do not claim myself to be an authority on that case, but I have read in a number of sources that at the last offer, a plea offer, that he accept a felony and some amount of time in jail that ranged from 3 months to 6 months. We see that there is a tremendous gap between what the law itself lays out, which could be a tremendous tool for a prosecutor to use in order to force someone to accept a plea bargain, even if they didn't think that they had violated the law. That is a big risk to take when you're looking at that kind of incarceration time, as well as the financial penalties. That's the most recent case. There are now 2 representatives in Congress, one from California and one from Oregon, who have taken on the issue as a result of the Aaron Swartz case. But I don't believe that they have had much traction in Congress to try to revise this law, and in particular, revise its consequences, and to marry the consequences to the intent and nature of the act itself.
Thanks, Tracy. You want to navigate us into the waters of electronic communications privacy?
You bet. So I'm going to go back into history a little bit, Supreme Court history, in order to situate this question. First, not on the slide, I should mention what I'm sure everyone knows, but it's worth repeating. In the original Constitution, the word privacy does not exist. The facsimile of what we now call privacy in the 20th century in the area of government would be mostly located in the Fourth Amendment of search and seizure with must have a warrant. And if people are familiar with some of the issues that emerged in the 60s, 70s, and 80s debates about privacy, you might remember the notion of a penumbra of the Bill of Rights, the First, Third, Fourth, Fifth, and Ninth Amendments, creating what Judge Goldberg called a penumbra of protective rights that kind of equal what the culture then in mid-20th century was starting to call privacy. Where it comes up in electronic communications is first in a case called Olmstead in 1928. There was a lot of bootlegging going on at that time, and of course there was a lot of legal surveillance of that criminal activity. And so the question came up in the use of the telephone. Did law enforcement require a warrant in order to survey telephone communications that were under their investigation? Case went to the Supreme Court, and the answer was no. The rationale was this is just a set of wires being attached with alligator clips on a black box, and that is not what our forefathers were talking about when they framed the Fourth Amendment. Give it a few more years, about 40, and we have a revisiting in the Supreme Court of the same more or less set of facts and legal posture question of, does law enforcement require a warrant in order to survey or attach wiretapping facilities to a phone line? And this time, the world has changed, the environment has changed, social norms, the market, and so forth. The answer comes out different. The court overrules Olmstead and establishes in the Katz case a Fourth Amendment protection for telephone. What were you doing in 1967, Richard? Is this your case? But I shall go on to that.
Name and act.
That the next year the Congress responded. And notice, here you have a case where the court has acted and Congress responds. There's a relationship going on between how things are changing and Congress's ability to act, contrasted to our current circumstance. They applied the Katz case and they created the Omnibus Safe Streets and Crime Control Act and made a very important distinction between what we call metadata and content for telephony. And not too many years later, we had a revision of that law because so much was changing in terms of technology that Congress rewrote it in order to maintain this Fourth Amendment mapping between that which gets protected, the content, and that which does not. And that would be the metadata, source and destination call numbers, timestamps, so forth. Here's the problem. Even though the Electronic Communications Privacy Act of 1986 is still the law that we have and had the intent of mapping the Fourth Amendment according to that division, it did not sufficiently appreciate the distinctions in how the technologies between telephony and data networking operate, such as not to recognize that data networking metadata actually cuts across that Fourth Amendment divide and map. And that is the basis upon which so much of what we now have to reckon with, whether it's the Patriot Act, whether it's the FISA court, whether it's what Snowden has disclosed that the NSA is doing, it's all based on that foundational act that mixes up the mapping of the Fourth Amendment. Telephony and internet technologies have different metadata, the tracking information. And I'm talking to experts here, so I don't need to weigh on this point. An internet protocol address sometimes can get you linked to web pages and offer content for far less than probable cause. And that is what law enforcement must bring to a judge and say that they have in order to press forward a case. And so all of the subsequent legislation that has amended ECPA, for example, and that's the acronym for the Electronic Communications Privacy Act, is fuzzied and confused because of this original conflict. And it has exacerbated problems then with FISA, and those are the secret courts, foreign intelligence surveillance courts, and many of our librarian friends would speak about this in terms of the Section 215, which is used without much showing at all, and especially under FISA, with an ex parte visit to a secret court to get quote-unquote billing records that in fact reveal content. This is a big part of why libraries have taken up the charge to object to that section in particular. As I alluded to under the Snowden disclosures, it's not clear then whether it was illegal or not for the National Security Agency to collect all telephone metadata. If they brought this request to the FISA court, they're simply saying, we just want the metadata. It doesn't take probable cause to get the metadata. It's filing a letter with a clerk of a court. And this discrepancy is how the government, I think, arguably, has gone on with the kind of business that does disturb people's sense of privacy, but in fact, under the laws that we have today, it is at least arguable that the government is acting legally. And without being able to go back and unwind all the pieces of this down to the Electronic Communications Privacy Act and its slippage on the Fourth Amendment, we will not be able to tackle this issue in a clear-eyed way that I think we need to in order to even expect Congress to act. And I want to emphasize that the FISA court is an ex parte proceeding. That means just the government shows up. The other side does not know they're under surveillance. That means they don't have a lawyer to go and argue their point. We have had organizations such as the ACLU attempt to stand in the shoes and argue for at least a representation before these courts, but they were found not to have standing. And I do hope that some of these reforms will begin to take some of these complex and compounding issues into perspective in order to rectify what clearly exists in the United States, which is significant dissonance over the activities of government, over what the law is, and how people feel about it. So where I would vest reform efforts would be to revise that ECPA to map the technology back to the Fourth Amendment. And if there's even one case to be made, it's because now even our telephony is under Internet Protocol address protocols and technologies, and so therefore it would seem we just even need to bring it up to date. But revising the Foreign Intelligence Surveillance Act for the same kind of mapping jurisprudence, that we really need to revisit many of those aspects. Recently, President Obama, through some executive order, has suggested that the number of correspondence or degrees of separation, so what do I mean by that? I mean, if I am under investigation, how many degrees out can they go from me, say in an email communication? So I write to Richard, and Richard writes to a friend of his, and then that friend writes to yet another person, and so forth. Where does the government draw the line that they can look? And President Obama has brought it in to 3 degrees of separation, but I'm here to tell you that the original milligram experiment that created the notion of 6 degrees of separation by virtue of the internet is now revised to 4 degrees of separation. In other words, every single person on the planet can have some connection to other people with only 4 degrees of separation now by virtue of networking. And so in effect we're saying that there is no limit if we take into account network effects on degrees of separation. In other words, just about everybody can be under surveillance. All of these need to be brought into how we would think about reform. And I would have to say that the telephone companies have carved out immunities for what they do so that they can't be prosecuted or made to pay any damages for their contribution to these efforts. And since we're all working through telecommunication companies, this is a significant question to ask. There is no technological oversight, which I think is really the foundational problem. People still don't understand the difference between telephony and data networking until we get people maybe from the National Academy of Sciences or other august bodies to help us with the very basic understanding of the technology. I think we're always going to be at a deficit. And I would ask, as an advocate as well as a lawyer, whether secret and ex parte courts are even commensurate with the democratic polity. I'll answer that question. I don't think they are. I think it's entirely possible that we could bring all this activity back into our regular criminal courts. Any questions about the material in this section, Richard?
Well, I'm intrigued as I listen to you, Tracy, because what you've described in this somewhat either ambiguous or dissonant or technologically lagging body of law is on a collision course with, of course, the trends in big data where in fact the creative and powerful ability to manipulate metadata to derive, if you will, very personal information, those two worlds are in complete opposition to one another. What's going to bring this to a head? Is Google going to say, we're not going to provide the government with not only content but metadata because we know how that can be used and it's our secret sauce? Right.
Well, that question is actually a perfect bridge to the next section on consumer privacy. And I think that you've really hit the nail on the head. And let me even give you a small example of why I think that. It is illegal still, in some senses, for the government to collect a lot of data on individuals. It would run into any variety of Fourth Amendment jurisprudence. But I'll tell you what's not illegal. If the United States goes and pays Axiom, ChoicePoint, Facebook, Google, for the information that they have. Now, whether those companies would agree to the deal, whether they would have either a business reason or legal ethical reasons not to do it are separate questions. My only point is it's not illegal for the government to do that. And so there is a very challenging connection between the issues of electronic surveillance by government that involve the Constitution, as I've just tried to describe, in these public laws such as ECPA, and consumer privacy. And you've hit the head of the nail with it. What will it take to change all of this? I honestly don't know. One would have thought that in the wake of the Snowden disclosures, maybe it was that. But then as we began saying, well, gee, maybe it's legal what the government's doing, people don't seem to be able to take that next step and say, well, why is it legal? What is the background of laws that might legitimate that activity? And even once understanding that, and I've only given a little overview of it, people were to say, hey, sometimes the laws are not right. We certainly were able to say that about issues such as segregation in the United States and turn ourselves around on that point. I don't know, frankly, what it will take in order to turn us around enough in this country. But I do know that it would take a revision of both consumer privacy and government surveillance in order for it to have a genuine salutary effect.
That's interesting. What's your thought? We have a wonderful question and a timely one. What are your thoughts about the recent Apple response to not sharing data, particularly in light of their recent announcements about the amount of credit card information they're holding and so forth?
I wish I were a little better versed into those details, and I'm afraid I'm not. But I will say this, that it still remains interesting to me that people put content in these repositories or social networking sites or photo sharing sites, believing and trusting that they will remain private in however they think private means. Daily there are reports about breaks, and anyone who believes that technology is fail-safe is sadly out of tune with how the network and all of its layers works. And so even just that fact alone surprises me, that people are still surprised when they find out about these lapses. And I would be happy to learn more about the Apple case. I haven't researched it well enough. I was at ICPL all last week, and I'm a little behind in my reading and so forth, and get back to the questioner about my specific position on Apple. But I would need to read a little bit more about it. But the overall trust that we have in the network still surprises me. I understand it from a human point of view. The network is an extension of an expression of ourself. I call it the Mount Tabor effect, where in the New Testament, and I'm not trying to be religious here, I'm being in classical literature, you have this notion that you see the divinity for the first time, the disciples do in that depiction. And I call that same effect into view of the internet, because there's something about putting something out there that helps us see ourselves better. And so I understand the motivation. It's a very deep one, I think, that brings us into usage of the internet in these ways, but it's often with a naive trust and belief that it's going to be secure. And that is part of information literacy that you mentioned at the forefront, Richard, that people really understand the context of what the internet is all about, for better and for worse.
Well, I love your biblical allusion, and you're way more generous than I am. I just think we've gone off the deep end of narcissism. But I digress. Thank you so much. You've kept us on marvelous track. We've got about a little less than 12 minutes left in the session. So if you want to jump into your next session, there will be enough time both for some questions there and to let Megan do a wrap-up.
Great. Well, I will speed along then, and a lot of this I'm pretty sure that our folks here already have deep information about. Facebook has been challenged many times because it pushes out personal information. Mark Zuckerberg keeps replying to these challenges by saying he knows better what you want than you do. Some of his programs, however, have created such pushback that now the FTC has looked into it as an unfair and deceptive consumer practice, and there is an agreement that Facebook cannot now, under regulatory rule, reset privacy settings without giving notice to the users. And many of you may recall the one case where the teacher thought everything was set to privacy, and she said somewhat euphemistically, I had a great day, didn't feel like killing one of my students. That night, Facebook switched up the privacy settings. She had a friend who was much more profligate with her friend connections that went out to students in the whole school, and she was put on administrative leave until they could work it out. That kind of thing now, at least users will get notice. And I guess I just already plowed through that slide, so we'll move on. And there are, the Federal Trade Commission has long required transactional sites to have a privacy policy, but what people may not know is that it doesn't have to say anything in particular. They simply have to say what it is they do. But the problem is they could say, we're going to sell all of your information to the lowest bidder. And that would be perfectly appropriate so long as the practice matched the statement. And it also doesn't matter if they change from one day to the next, so long as the practice that day and the statement map up. And so even though the FTC has demonstrated itself willing to start looking into some of these problems, there are whole lots of gaps and area for them to continue to look at. In Facebook itself no longer even has a privacy policy. If you go and click on what says privacy policy on its front page, you will go to a statement called a data use policy, and it will be very clear to you that Facebook can do whatever it wants with your data. You hold the copyright to it. They don't give that up. But they make it really pretty clear. It's in nice language, but it's pretty clear that they're going to do with that data what they want, including not telling you that you are the subject of an academic study. And if we had more time, we could go into that case. Google, another example of a big internet titan, had its Street View in Germany reacted. There were fines. There also was settings on how they picked up data as they were going through the streets that turned out to be an intentional configuration of an engineer. There was a whole issue about disclosing his identity. In the end, the FTC, when they looked at this question, they said, well, Google didn't really do anything wrong with its Street View, but they obstructed justice by not disclosing the engineer who was in charge of that configuration. We now know his name is Marius Milner, and he's had a long track record in this kind of area. Now, currently in Europe, we have the right to be forgotten. It just went into effect this summer. It's only in Europe. This is the situation where, say, if you committed a crime when you were a young person, let's take Robert Morris. You still could look him up and find out about his case. In Europe, he may apply through the administrative process at Google to be forgotten. And those pages will be taken down. And not only could you not get them if you're, say, in google.it, Italy, and doing a search on him, but even if you used from an Italian IP address space, went to google.com, and looked him up, you still wouldn't be able to find him. So they've gone at least 2 layers in the technical support of this ruling. It reminds me a bit as to the Yahoo case that originally demonstrated that governments do intervene in the Internet, and the Internet and cyberspace are not beyond laws and national jurisdictions. In the United States, Google's privacy policies were various across applications, and the FTC determined that this was a deceptive practice. They fined them a small sanction, $25,000, and subsequently Google has harmonized those policies. The Gmail litigation that's ongoing now in the District San Jose Court under Judge Koh, and she is someone to watch, is very interesting and will be for this audience, because through a discovery process that's acting on behalf of consumers, so this is regular consumer Gmail case, it was discovered that Google was not turning off its data mining functions, even in its enterprise contract accounts. This really could be fodder for a very massive investigation in terms of FERPA violations, among other potential violations. And I'm surprised that I haven't seen more about it in the higher education press, to tell you the truth. Very quickly, Google has said, oh, I guess we figured out a way to do it. We're not doing that anymore. But going back, the promise that Google made to higher education in those enterprise contracts not to show ads. Many people in higher education thought that meant that they weren't going to data mine. And we now know through this case that was not true. They continued to data mine it. If I were in a position with an association or something of influence, I really would be pressing Google to demonstrate through some third party that they are now living up both to the spirit and the letter of those contracts and not violating FERPA through data mining for their own business purpose. And that brings us up to Q&A. What a very exciting little moment to ask on that.
Yeah, it sure is. Let me quickly go over two questions with you, Tracy. One is my own, and that is I'm very concerned about the right to be forgotten, and in particular the prevention of circumvention that you mentioned of going to google.com. This is just another form of the, if you will, nationalization or regionalization of information, so that when you live in the United States, you go to google.com. When you live in Europe, you go to, and then it becomes in Saudi Arabia, you go to, or in China, Russia, you name it. Is there any international forum, legal forum, or policy forum for harmonizing things like this, so that we don't wind up having a world in which information falls into these kinds of regional national stovepipes?
The fast answer, Richard, is no, but of all the things we need, I believe right now in the world, it would be some form of global internet governance. The work that the Berkman Center is doing in this area, led by Urs Gasser, who's the executive director there, and I believe it's called the Global Network Initiative, is something to for interested listeners to look into and work on. And he is looking for higher education partners because this is very special. He is taking the position, and I couldn't agree with him more, that higher education has something to offer here, that we think internationally. Our missions are humane and human in scope, and to have, for example, right now an ongoing undeclared cyber war. This is cyber attacks being supported and prompted from nation states that cannot be regulated because there is no body to regulate it, really suggests that in a global information economy, we're all off on the wrong foot. We have moved ahead with the economy, but we don't have a legal way to manage it. And so the only effort that I know of that is looking at this challenge from the higher education's perspective is out of the Berkman Center under the direction of Urs Gasser, and I highly recommend it. In the meantime, what we have are various attempts through the United Nations and telecommunication international bodies that are turning out to be like a light switch. It's either going to be Russia and China against Western countries like Britain and the United States, or zip. And what a broad multi-factored stakeholder approach would do, I think, really would complement what most people think of and believe in when they think of the Internet. But I see we're running out of time, and so perhaps I'll leave it at that.
Yeah, if you could in the next 20 seconds, so we leave Megan some time, is the right to be forgotten a Google issue only, or is this a broader issue?
It's a broader issue. It's part of European law, but Google has 90% market share in Europe, unlike 65% in the United States, 90%. And so it was very important that the right to be forgotten be brought specifically to Google for some type of administrative process to address it. But it's broader than Google itself.
Well, thank you so much, and I wish I could gush for a longer period of time. But I'm going to ask Megan, do you want to wrap us up?
Yes, and I want to say thank you, Richard and Tracy. This was very well done, and the questions from the audience have been very, very good. I believe we got to all of the questions. If you have any remaining questions, go ahead and put them in the chat box. I'll leave it open for a little while. But thank you, Tracy and Richard. This was very, very valuable to our community. I'm going to just cruise through this next section and get to our wrap-up. If this is your first experience with WCET, get on our website and learn more about us. We have an annual meeting coming up in beautiful Portland, November 19th to the 21st, and that is open to everybody. The program is posted, so I encourage you to get on and peruse. If you join WCET, we have numerous member benefits, including these free webcasts. We have a very active listserv, discounted access to our activities, including our annual meeting. And as I mentioned, this is being recorded. It'll be posted on our website next week, and we'll also post a link to the YouTube account where all of our webcasts are housed. And I'll send all of those materials and resources out to you as soon as I can, probably early next week. Thank you again to Blackboard Collaborate for making the platform available. Thank you to our WCET supporting members. Thank you to our annual sponsors, Blackboard, CourseSmart, and VitalSource, Pearson Learning Solutions. And thank you again to Richard and Tracy. Take care.
Thanks, Megan.
Thanks, everyone.